What are some of the preliminary steps that you, as the attorney, will take on behalf of your client in the debt collection process? Attorney Art Matthews explains. When a client contacts us about an unpaid account or a debt that needs to be collected, we will first talk to them on the phone. We have some clients with multiple accounts for whom we've developed prearranged procedures, so we don't need to talk to them on the phone every time. We like to hear what the situation is, whether there are any disputes the other side is raising regarding why they haven't paid. Are they ignoring you? Are they claiming they have no money? If the facts warrant that we pursue the matter, we'll ask the client to provide us the documentation, i.e. the purchase orders, contracts, invoices, check copies, credit applications, and tax ID numbers, etc. Once we have this documentation, we will review it to determine whether it is secured or unsecured debt, which will guide us on how we proceed. We also verify how old the debt is. In California, the breach of a written agreement or unpaid account must be pursued within 4 years, meaning you can't wait more than 4 years from the date the debt became due or the last payment was received to file a lawsuit, or the lawsuit can be thrown out by the court because the statute of limitations has run out. We have unfortunately had clients approach us with debts that are more than 4 years old and have had to break the news that they cannot pursue the debt in court. Statute of limitations are firm deadlines, so clients should not wait too long to pursue an unpaid debt. If the documentation includes a written contract, we will review it to determine if there is an arbitration clause, a mediation clause, or both. Some of our clients would rather go to arbitration, which is private, than file a lawsuit in court, which becomes a public record. This step helps us determine where we'll be if we have to take legal action. Some contracts even tell us where we have to sue. For instance, it might be Northern California instead of Orange County, Los Angeles County, or Southern California. We obviously have to make sure we are filing the lawsuit in the right place. Then, we will identify all of the responsible parties. Hopefully, there is a personal guarantee, meaning one of the owners or principals is responsible to pay the balance, not just the business. That usually makes the debt more collectible, especially if you are dealing with a company that is going out of or has already gone out of business. When we have an individual who is also responsible, we can pursue their personal assets, which gives us significant leverage. Matthews Law Firm's primary goal is to provide high-quality legal services for a fair and reasonable price. We welcome any opportunity to help clients fight for their corporate rights.